Namaskar. Good morning, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officer, officials, listener, learners. I welcome all respected doctors and directors. I welcome all adorable advocates, supervisors, and administrative advisors. I welcome honorable ministers, managers. I welcome the most honorable President Pravish Modi. Dr. Rakesh from USA, heartily welcome. Really nice time, nice place, nice action. You are listening to channel 3M Creator. Today, it is very nice time that we are defining, describing and explaining our holy Indian cultural, spiritual, social identities in the form of unity and diversity. Today, let us go through what is happening around the world. रक्षात्मक कार्रवाई में यूएस को ब्रिटिश सैनिक कराने इस्तेमाल करने की अनुमति। जान में आक्रामक कार्रवाई में शामिल नहीं होगा ब्रिटेन इसका शेष। यरूशलेम में ईरानी मिसाइल हमले में 7 लोग घायल। लेबनान से उत्तरी इजराइल में दागे गए रॉकेट। राष्ट्रपति ट्रंप ने इजराइल, बहरीन और यूएई के नेताओं से की बात। यूएई ने तेहरान में अपना दूतावास बंद करने की घोषणा की। यूएई ने ईरान से अपना राजदूत वापस बुलाने का लिया फैसला। E3 देशों ब्रिटेन, फ्रांस, जर्मनी ने ईरान संघर्ष पर जारी किया बयान। अमेरिका और अन्य साथियों के साथ काम करने पर हुए सहमत। केंद्रीय कैबिनेट की सुरक्षा मामलों की सहमति की भी बैठक। पीएम मोदी की अध्यक्षता में हुई सीसीएस की बैठक। पश्चिमी एशिया में जारी संकट के बीच हुई बैठक। पीएम मोदी की यूएई के राष्ट्रपति से फोन पर बातचीत। यूएई पर हुए हमलों की कड़ी निंदा। भारत इस मुश्किल समय में यूएई के साथ खड़ा है, पीएम से। यूएई में रह रहे भारतीय समुदाय का ध्यान रखने के लिए जताया आभार। तनाव कम कर क्षेत्र में शांति, सुरक्षा व स्थिरता का करते हैं समर्थन। पीएम मोदी की इजरायली पीएम नेतन्याहू से फोन पर बात। मौजूदा क्षेत्रीय स्थिति को लेकर हुई बातचीत पीएम मोदी से। हाल के घटनाक्रम पर भारत की चिंताएं साझा की पीएम मोदी से। संघर्ष जल्द खत्म करने पर भारत का जोर। नागरिकों की सुरक्षा को प्राथमिकता। दुबई और आबू धाबी के शेयर बाजार 2 दिन के लिए बंद। अमेरिकी राष्ट्रपति डोनाल्ड ट्रंप का बड़ा बयान। बातचीत करना चाहता है ईरान, डोनाल्ड ट्रंप से। ईरान की ज्यादातर लीडरशिप खत्म हो चुकी है। डोनाल्ड ट्रंप से ईरान को पहले ही बातचीत कर लेनी चाहिए थी। हमने ईरान के नौसैनिक जहाज डूबाए। ट्रंप क्लेम्स ईरान में 1000 से अधिक ठिकानों को बनाया निशाना। अगले 4 हफ्ते तक चल सकती है लड़ाई। सभी लक्ष्य पूरे होने तक जारी रहेगी लड़ाई। ट्रंप की ईरानी सुरक्षा बलों को चेतावनी, सरेंडर करो या जान गंवाओ। हमलों में 3 अमेरिकी सुरक्षा बलों ने गंवाई जान। अमेरिकी सुरक्षा बलों की मौत का बदला लिया जाएगा, ट्रंप से। रक्षात्मक कार्रवाई में यूएस को ब्रिटिश सैन्य ठिकाने इस्तेमाल करने की। ईरान में आक्रामक कार्रवाई में शामिल नहीं होगा, ब्रिटेन स्टार मैसेज। यरूशलेम में ईरानी मिसाइल हमले में 7 लोग घायल। लेबनान से उतरी इजराइल में दागे गए रॉकेट। राष्ट्रपति ट्रंप ने इजराइल, बहरीन और यूएई के नेताओं से की बात। यूएई ने तेहरान में अपना दूतावास बंद करने की घोषणा की। यूएई ने ईरान से अपना राजदूत वापस बुलाने का लिया फैसला। E3 देशों ब्रिटेन, फ्रांस और जर्मनी ने ईरान संघर्ष पर जारी किया बयान। E3 देशों ने क्षेत्र में हितों की रक्षा के कदम उठाने। केंद्रीय कैबिनेट की सुरक्षा मामलों की समिति की बैठक। पीएम मोदी की अध्यक्षता में हुई CCS सेंटर के बीच हुई बैठक। पीएम मोदी की यूएई के राष्ट्रपति से फोन पर बातचीत। यूएई पर हमले की कड़ी निंदा की पीएम मोदी। भारत के इस मुश्किल समय में यूएई के साथ खड़ा है। भारत इस मुश्किल समय में यूएई के साथ खड़ा है, पीएम मोदी से। यूएई में रह रहे भारतीय समुदाय का ध्यान रखने के लिए जताया आभार। तनाव कम कर क्षेत्र में शांति, सुरक्षा व स्थिरता कायम करने का समर्थन। मौजूदा क्षेत्रीय स्थिति को लेकर हुई बातचीत। हाल के घटनाक्रम, संघर्ष जल्द खत्म करने पर भारत का जोर, पीएम मोदी से। नागरिकों की सुरक्षा को प्राथमिकता। अमेरिकी राष्ट्रपति डोनाल्ड ट्रंप का बड़ा बयान। बातचीत करना चाहता है ईरान, ट्रंप से। डोनाल्ड ट्रंप से हमने ईरान के 9 सैनिक जहाज डुबोए। ईरान में 1000 से अधिक। अगले 4 हफ्ते तक चल सकती है लड़ाई। सभी लक्ष्य पूरे होने तक जारी रहेगी लड़ाई। ट्रंप की ईरानी सुरक्षा दागनी सेटल करो या जान गवाओ। रक्षात्मक कार्रवाई में यूएस व ब्रिटिश सैन्य ठिकाने। ईरान में आक्रामक कार्रवाई में शामिल नहीं। यरूशलेम में ईरानी मिसाइल हमले में 7 लोग घायल। लेबनान से भारत राष्ट्रपति ट्रंप ने इजराइल, बहरीन और यूएई के नेताओं से की बात। यूएई ने तेहरान में अपना दूतावास वापस बुलाने का लिया फैसला। केंद्रीय कैबिनेट की सुरक्षा मामलों की समिति की हुई बैठक। पीएम मोदी की अध्यक्षता में हुई सीसीएस की बैठक। यूएई पर हुए हमलों की कड़ी निंदा की पीएम मोदी से। तनाव कम कर क्षेत्र में शांति सुरक्षा स्थिरता का करते हैं समर्थन। घटनाक्रम पर भारत की चिंताएं। दुबई और अबू धाबी के शेयर बाजार 2 दिन के लिए बंद। ईरान को पहले ही बातचीत कर लेनी चाहिए थी। सभी लक्ष्य पूरे होने तक जारी रहेगी लड़ाई। अमेरिकी सुरक्षा बलों की मौत का बदला लिया जाएगा, ट्रंप से। Now, let us start international law and human rights. Difference between protectorate and vassal states. There are the main points of difference between a protectorate state and a vassal state. Often through a treaty, a protectorate state entrusts its matters of security, defense, and national affairs to another state. A vassal state is autonomous in its internal matters but is completely dependent upon other state in external matters. A protectorate state may become a member of the international community. A vassal state is not regarded a member of the international community. A protectorate state is not completely sovereign, and in fact, its sovereignty is taken by the country of which it becomes a protectorate state. A vassal state is a semi-sovereign state. If the protecting state declares a war against any country, then the protectorate state is not necessarily involved in that war. Thus, the treaty entered into by the protecting state is not binding upon the protectorate state. In the case of a vassal state, it is bound by the treaty entered into by the protecting state. Protectorate state may remain a state, but a vassal state is completely under the suzerainty of another state and has no separate and independent existence under international law. Trust territories have been discussed in detail and titled the Trusteeship Council thereof say that chapter International Position of Tibet Policy or Vatican City and Commonwealth of Nations. Tibet is a mountainous region in between India and China. खामेनी की मौत के बाद ईरान अमेरिकी राष्ट्रपति डोनाल्ड ट्रंप से मकसद पूरा होने तक जारी रहेगा हमला नागरिकों की सुरक्षा को प्राथमिकता मॉरिशस ईरान बात करना चाहता है मैं भी बातचीत के लिए तैयार ट्रंप से अमेरिकी राष्ट्रपति डोनाल्ड ट्रंप का बड़ा बयान सभी लक्ष्य पूरे होने तक जारी रहेगी लड़ाई डोनाल्ड ट्रंप से बातचीत करना चाहता है ईरान is a mountainous region in between India and China. In 1720 it was an independent state, but later on it was incorporated by China in its state after the end of the region of Manchu dynasty of China. Tibet became free from the suzerainty of China. In 1906, Tibet was brought under the joint protection of China and Britain. After some years, the control of China over Tibet ceased and it again became an independent state. However, in its external affairs, China continued to exercise control over it. In Shimla Conference of 1940, Tibet was declared autonomous in its internal matters and was regarded to be under the protection of China. The next landmark event was the Treaty of 1951, whereby Tibet was regarded as a protectorate state of China. China accepted the Dalai Lama as the spiritual head of Tibet, thus Tibet was autonomous in its internal matters but was under control of China in its external matters. It may, however, be noted that China flagrantly violated the Treaty of 1901 and started interfering in the internal matters of Tibet in 1959. The situation deteriorated so much that the conflict took the form of a war between China and Tibet. China sent its forces in Tibet and ruthlessly suppressed the movement of people. Dalai Lama, the spiritual head of Tibet, was compelled to leave Tibet. He fled away from Tibet and took ashram in India. Thus, Tibet is a protectorate state, but because of the autocratic and imperialistic policy of China, it has been converted into a vassal state and the rights of citizens of Tibet are frequently violated and Tibetan are at the mercy of the government of China. But time and again, India has declared that Tibet is a protectorate state of China and its affairs are internal matters of China. पीएम मोदी की अध्यक्षता में हुई सीसीएस की बैठक बदलते हालात पर भारत की नजर पश्चिमी एशिया में जारी संकट के बीच हुई बैठक बातचीत के लिए तैयार ईरान पीएम मोदी की यूएई के राष्ट्रपति से फोन पर बातचीत के लिए तैयार ईरान यूएई पर हमलों की कड़ी निंदा की प्रधानमंत्री नरेंद्र मोदी बीजेपी का मिशन बंगाल भारत इस मुश्किल समय में यूएई के साथ है यूएई में रह रहे भारतीय समुदाय का ध्यान रखने के लिए जताया आभार तनाव कम कर क्षेत्र में शांति सुरक्षा व स्थिरता का करते हैं समर्थन पीएम मोदी की इजरायली पीएम नेतन्याहू से फोन पर बातचीत T20 वर्ल्ड कप सेमीफाइनल में भारत सेमीफाइनल में पहुंचा भारत T20 वर्ल्ड कप मौजूदा क्षेत्रीय स्थिति को लेकर हुई बातचीत पीएम मोदी से हाल की घटनाक्रम पर भारत की चिंताएं साझा की पीएम मोदी से होली सी और वेटिकन सिटी होली सी और वेटिकन सिटी is a place where the religious and of Catholic Christians Pope resides. Holy See is smallest sovereign state in the middle of 19th century. The rulers of Italy seized the territory of Pope and occupied his capital. Rome consequently, Pope went away and settled in his residential place called Vatican City. Since Pope was the religious head, the government of Italy passed a law in 1871 whereby some guarantee was given to Pope. This said act conferred some privileges and immunities upon Pope more or less equal to those privileges and immunities which are enjoyed by head of the state. Next important change took place in 1929 when a treaty was concluded between Pope and the government of Italy whereby Vatican City comprising of 100 acres of land was accepted as a state and Pope was conferred upon the rights to enter into diplomatic relations with other states. Thus, by the Treaty of 1929, Vatican State assumed the status of an international person under the international law. The person position of Vatican City is that it is an international person and possesses all the rights and duties of sovereign state. It is a national state. It is not a member of the United Nations. In short, Vatican City is an international person and is fully independent and sovereign state under international law. Commonwealth of Nations, except Britain, Commonwealth of Nations is an association of those states which were at some time the colonies of the British Empire before 1948. It was called the British Commonwealth of Nations. Slowly and gradually, the British colonies became independent one by one, and their liberation, their attitude also underwent significant changes. After the attainment of independence, these liberated states were not prepared to accept the suzerainty of overlordship of any other state. In the conference of 1948, a resolution was passed that the members of the British Commonwealth of Nations will be autonomous in their internal matters. As pointed out earlier, significant changes had appeared in international field by the year 1948. Consequently, the word British was dropped and was named only Commonwealth of Nations. The present position is that all the members of the Commonwealth of Nations are sovereign states. They are fully independent and may exchange diplomatic advice in foreign affairs. Their powers are unlimited. They can enter into treaty and may make declaration of war or peace on the basis of their So one powers the Commonwealth of Nations has 1/3 of world population. It has 53 current members. They are 18 from Africa, two in America, 12 in Caribbean, 3 in Europe, 10 in South Pacific, 8 in Asia, 53 current members are there in Commonwealth nation, one third of world population. Legal status of Commonwealth of Nations. Commonwealth of Nations is neither a state nor a federation. It is only a association of equal and sovereign states who are members of the United Nations and agree to follow certain principles under international law. The Commonwealth of Nations is not a separate independent entity. It is only a loose association of independent states so far as India is concerned. She has made it clear that India is a sovereign democratic republic. India has joined Commonwealth of Nations on the basis of equality, and the membership of Commonwealth of Nations depends upon the sweet will and discretion of India. Natural state and neutralized state and distinction between them. We have to discuss it. हमलों में करीब के मारे जाने की खबर अमेरिकी राष्ट्रपति डोनाल्ड ट्रंप का बड़ा बयान हिजबुल्लाह ने इजराइल पर दागी इजराइल घर चरमपंथी संगठन हिजबुल्लाह ने सीमा पार इजराइल बेरूत पर इजराइल का हमला ईरान की ज्यादातर लीडरशिप खत्म हो चुकी है डोनाल्ड ट्रंप से ईरान को पहले ही बातचीत कर लेनी चाहिए थी डोनाल्ड ट्रंप एक्सप्रेसेस हमने ईरान के 9 सैनिक जहाज ट्रंप से ईरान जवाबी कार्रवाई से पीछे नहीं हटेगा ईरान का बयान ईरान के राष्ट्रपति मसूद पेजेश्कियान का संदेश हमला मुसलमानों के खिलाफ युद्ध की घोषणा ईरान का बयान ईरान को बदला लेने का पूरा अधिकार डोनाल्ड से सभी लक्ष्य पूरे होने तक जारी रहेगी लड़ाई ईरान दुश्मनों पर हमले जारी रखेगा ईरान से ईरान के राष्ट्रपति मसूद पेजेश्कियान का संदेश ईरान ने खामेनेई को शहीद घोषित किया हमलों में 3 अमेरिकी सुरक्षा बलों ने गंवाई जान ईरान की जनता से एकजुट होने की अपील ईरान का प्यार ईरान की जवाबी कार्रवाई ईरान के राष्ट्रपति मसूद पेजेश्कियान का संदेश ईरान जवाबी कार्रवाई से पीछे नहीं हटेगा रक्षात्मक कार्रवाई में यूएस को ब्रिटिश शहरें ठिकाने ईरान में आक्रामक कार्रवाई में शामिल नहीं होगा ब्रिटेन versus state responsibility. What is state responsibility? Since formerly states alone were recognized as subjects of international law, the general topic of international responsibility for wrong used to be discussed under the heading state responsibility, though international responsibility now also involves consideration of position of international organizations and individuals for the sake of convenience. The topic of international responsibility is still studied under the heading state responsibility. What is the meaning of the term state responsibility? Often it is said that the sovereign has no obligation under law. This statement is true only in respect of the subjects of the sovereign because a state may change its law at its will and may thus bring about changes in its obligations. The position is, however, different in respect of the obligations towards other nations. In that respect, obligations of the state are that of an international person. A state has certain obligations under international law. The state responsibility concerning international duties is therefore a legal responsibility. For a state cannot abolish or create international law in the same way that it can abolish or create municipal law. Thus, the rules of international law as to state responsibility concern the circumstances in which and the principles whereby the injured state becomes entitled to redress for the damage suffered. The Giorgio Factory indemnity case, the Permanent Court of International Justice said, if it is the principle of international law and even a general conception of law that any breach of an engagement involves an obligation to make reparation. In the Corfu Channel case, the International Court of Justice held Albania responsible for the explosions which occurred and observed this grave omission involved the international responsibility of Albania, and there is a duty upon Albania to pay compensation to the United Kingdom. As pointed out by Starr, the law of state responsibility is still in evolution and may possibly advance to the state where individuals are also faced with the responsibility for breaches of international law which are international crimes. State responsibilities during the war have been generally accepted in Article 3 of the Hague Convention 1907. According to it, if a, by, if a belligerent state violates rules of war, it shall be responsible for the payment of compensation. It shall also be responsible for the acts committed by persons of its armed forces. The state responsibility, like the question of the definition of aggression, is a pedigree subject. It was considered by the Hague Conference of 1930. It has been considered by the Commission in the early 50s, but the present work has been done since 1969 by Professor Ago as the special rapporteur. The subject of the current work of the UN International Law Commission on State Responsibility is to codify the rules governing state responsibility as a general and independent topic under the general plan for the draft on state responsibility adopted by the Commission. The origin of international responsibility forms the subject of part 1 of the draft, which is concerned with determining on what grounds and under what circumstances a state may be held to have committed an internationally wrongful act, which as such is a source of international responsibility. Part 2 deals with the content, forms, and degrees of international responsibility. That is to say, the determination of the consequences an internationally wrongful act of state may have under the international law, reparative and punitive consequences of an international wrongful act, relationship between these two types of consequences, material forms, which reparation and penalties may take. Once these two essential tasks are completed, the Commission may, if it seems fit, decide to add to the draft Part 3 concerning the settlement of disputes and the implementation by the 42nd session in 1992. 1990, the Commission had provisionally adopted first reading of 35 articles relating to first phase of its work. First 5 articles of second phase were also adopted. What are the kinds of state responsibility? Original and vicarious responsibility. Original responsibilities of the state are for the works of its government, and vicarious responsibilities are for its citizens and the works done by its agents when the private leaders of a state cause harm to other states. So the question of vicarious responsibility arises. In such a situation, it becomes the duty of the state to punish the individuals concerned and compel them to pay compensation. Original responsibility is borne by a state for acts which are directly imputable to it, such as acts of its government or those of its officials or private individuals performed at the government's command or with its authorization. On the other hand, arises out of certain internationally injurious acts of private individuals, whether nationals or aliens or allies in the state's territory, and of officially acting without authorization. It is apparent that the essential difference between original and vicarious responsibility in this sense is that whereas the former involved a state paying in direct breach of legal obligations binding on it and is accordingly a particularly serious matter. The later, the state's responsibility is at once to remove the injurious conduct of. In such cases, the state's responsibility calls for it to take certain preventive measures and requires it to secure that, as far as possible, the wrongdoer makes suitable reparation and, if necessary, to punish him. But these preventive and remedial obligations of the state in cases of vicarious responsibility are themselves obligations for the breach of which, as by refusing to take the remedial action which is required, the state bears direct responsibility. It is to be admitted that the legal consequences of the two categories of acts may not be the same, but there is no fundamental difference between the two categories, and in any case, the use of vicarious responsibility here is surely erroneous. हमलों में 3 अमेरिकी सुरक्षा बलों ने जमाईजान गिरावट के साथ खुला शेयर बाजार। अमेरिकी सुरक्षा बलों की मौत का बदला लिया जाएगा, ट्रंप से। रक्षात्मक कार्रवाई में यूएस को ब्रिटिश सेनेट ठिकाने इस्तेमाल करने की अनुमति। ईरान में आक्रामक कार्रवाई में शामिल नहीं होगा ब्रिटेन, स्टार मैसेज। यरूशलेम में ईरानी मिसाइल हमले में 7 लोग घायल। लेबनान से उत्तरी इजराइल में दागे गए रॉकेट। राष्ट्रपति ट्रंप ने इजराइल, बहरीन और यूएई के नेताओं से की बात। यूएई ने तेहरान में अपना दूतावास बंद करने की घोषणा की। यूएई ने ईरान से अपना राजदूत वापस बुलाने का लिया फैसला। E3 देशों ब्रिटेन, फ्रांस, जर्मनी ने ईरान संघर्ष पर जारी किया बयान। E3 देशों ने क्षेत्र में हितों की रक्षा के लिए कदम उठाने की कही बात। अमेरिका और अन्य काम करने पर हुए सहमत। मिडिल ईस्ट संघर्ष का बाजार पर असर, शेयर बाजारों में भारी गिरावट के साथ खुला शेयर बाजार, सोने और चांदी की कीमतों में तेजी। पीएम मोदी की अध्यक्षता में हुई सीसीएस की बैठक। पश्चिमी एशिया में जारी संकट के बीच हुई बैठक। पीएम मोदी की यूएई के राष्ट्रपति से फोन पर बातचीत। यूएई पर हुए हमलों की कड़ी निंदा की पीएम मोदी। मिडिल ईस्ट संघर्ष का बाजार पर भारत इस मुश्किल समय में यूएई के साथ खड़ा है, पीएम मोदी से। यूएई में रह रहे भारतीय समुदाय का ध्यान रखने के लिए जताया आभार। तनाव कम कर क्षेत्र में शांति, सुरक्षा व स्थिरता का करते हैं समर्थन। पीएम मोदी की इजरायली पीएम नेतन्याहू से फोन पर बात। मौजूदा क्षेत्रीय स्थिति को लेकर हुई बातचीत पीएम मोदी से। हाल के घटनाक्रम पर भारत की चिंताएं साझा की। संघर्ष जल्द खत्म करने पर भारत का जोर। State responsibilities in different fields of consequences of state responsibility. International delinquency, as pointed out by Professor Open Game, and international delinquency is any injury to another state committed by the head or government of a state in violation of an international legal duty, equivalent to acts of the head and government are acts of officials or other individuals commanded or authorized by the head of government. The comprehensive notion of an international delinquency ranges from ordinary breaches of treaty obligation involving not more than pecuniary compensation to violations of international law amounting to a criminal act in the generally accepted meaning of the term international delinquency is a term applying both to wrongs and consisting of breaches of treaties and to wrongs independent of treaty may be committed in regard to different objects. Thus, a state may be injured in regard to its independence through unjustified intervention in regard to its treaty rights through an act violating a treaty, or in regard to its right of protection over citizens, or through an act that violates the person or the property of one of its citizens abroad. Clark has explained the term international delinquency in the following words. In practice, most cases of state responsibility, at least before international tribunals, arise out of wrongs alleged to have been committed by the state concerned. By wrong in this connection is meant the breach of some duty which rests on a state and international law and which is not the breach of a purely contractual obligation. To such wrongs, more frequently the term international delinquency is applied. Most of the cases that come under this head concern injuries suffered by citizens abroad. Generally speaking, a person who was to live in the territory of foreign states must submit to its law. But that is not to say that certain duties under international law in respect to the treatment of the person do not bind the state. Examples are the duty of the state to provide proper judicial remedies for damage suffered and the duty to protect alien citizens from gratuitous personal injury by its officials or subjects. Thus, according to Stark, international delinquency is a wrongful act committed by a state which has only contractual obligation. International delinquency is a wrongful act which is a breach of international obligation and is independent of any contractual obligation. On the other hand, crimes are violations of customary or treaty rules of international law. For international delinquency, generally the remedy is pecuniary compensation. The remedy of international crime may be the punishment or reparation as the case may be. It is in respect of a crime against international law. The observation of the number judgment has the number judgment that individuals who commit crimes against international law may be punished is relevant as compared to it. International delinquency is a wrongful act committed by an official or organ of the state concerned which may be imputed or attributed to the state. Mention of imputability, as pointed out by state, is the subject of international delinquency. It is important to apply the notion of imputability. This notion assists in clarifying the subject and in providing the proper framework for its theory. To take a practical example, if an agency of state X has caused injury to a citizen of state Y in breach of international law, technically we say that state X will be responsible to state Y for the injury done. What this means is that the organ of official of state X has committed a wrongful act and the conduct in breach of international law is imputed from the organ or official to the state. The imputation is thus the result of the intellectual cooperation necessary to bridge the gap between the delinquency of the organ or official and the attribution of breach and liability to the state. Imputability therefore depends on the satisfaction of two conditions. One is conduct of a state organ or official in breach of an obligation defined in a rule of international law. Two is that according to international law, the breach will be attributed to the state. It is only if the breach is imputable that the state becomes internationally responsible for The delinquency responsibility begins where imputability ends, but as rightly remarked by Browning in General Broad formula on trade responsibility are unhelpful, and when they suggest manipulation, municipal analogies, a source of confusion. Thus, it is often said that responsibility only arises when the act or omission complaint of its imputable to the state. Imputability would seem to be a superfluous notion, since the major issue in a given situation is whether there has been breach of duty. The content of imputability will vary according to the particular duty, the nature of the breach, and so on. Imputability implies a fiction where there is none and conjures up the idea of vicarious liability where it cannot apply. Reference may be made here to Yamuna's case. In the case, the mayor of the Yamuna in Mexico ordered the lieutenant of state forces to suppress riots and attack against curtail American citizens instead of dispersing the rioters. The troops did just the reverse. They started firing on the house in which the Americans had taken refuge. In the process, one American was killed. The other two Americans were forced to leave the house and were killed by the troops and rioters. In opening the fire against the Americans, the troops had disobeyed the orders of the mayor and had acted beyond the scope of their authority. The Mexican government was held liable for the wrongful acts of the troops. It is sometimes said that a state is not responsible to another state for unlawful acts committed by its agents unless such acts are committed willfully and maliciously or with culpable negligence. It is difficult to accept so wide a conclusion and so a requirement. A general floating condition of malice or culpable negligence contradicts the scientific and practical considerations underlying the law as to state responsibility. It is only in specific cases when particular circumstances demand it that willfulness or malice may be necessary to render a state responsible. For example, if the state knowingly lies in the wrongful acts of insurgents or rioters, it would become liable, although not generally otherwise. Whether the actual decision of international arbitral tribunals fail to justify a general condition of malice or culpable negligence. In the word of another author, the fact that an ultra-vires act of an official is accompanied by malice on his part, that is, an intention to cause harm, without regard to their or not the law permits the act does not affect the responsibility of his state. Indeed, the principle of liability and their general propositions of this sort should not lead to the conclusion that dollars cannot play a significant role in the law. Proof of dollars on the part of leading organs of the state will solve the problem of imputability in the given case. And in any case, the existence of a deliberate intent to injure may have an effect on remoteness of damage as well as helping to establish the breach of duty. Malice may justify the word of penal damage. डोनाल्ड ट्रंप से अगले 4 हफ्ते तक चल सकती है लड़ाई डोनाल्ड ट्रंप से सभी लक्ष्य पूरे होने तक जारी रहेगी लड़ाई ट्रंप की ईरानी सुरक्षा बलों को चेतावनी सरेंडर करो या जान लो अमेरिकी सुरक्षा बलों की मौत का बदला लिया जाएगा ट्रंप से रक्षात्मक कार्रवाई में यूएस को ब्रिटिश सैन्य ठिकाने इस्तेमाल करने की अनुमति ईरान में आक्रामक कार्रवाई में शामिल नहीं होगा ब्रिटेन स्टारबशेश। यरूशलेम में ईरानी विजय हमले में 7 लोग घायल। लेबनान से उत्तरी इजराइल में दागे गए रॉकेट। राष्ट्रपति ट्रंप ने इजराइल, बहरीन और यूएई के नेताओं से की बात। झुकने को तैयार नहीं ईरान, जारी है हमले और बयान। यूएई ने तेहरान में अपना दूतावास बंद करने की घोषणा की जारी। यूएई ने ईरान से अपना राजदूत वापस बुलाने का लिया फैसला। E3 देशों ब्रिटेन, फ्रांस, जर्मनी ने ईरान संघर्ष पर जारी किया बयान। E3 देशों ने क्षेत्रों में हितों की रक्षा के लिए कदम उठाने की कही बात। घटे नाम, बड़ी टेंशन, ममता को अब धरने का सहारा। केंद्रीय कैबिनेट की सुरक्षा मामलों की समिति की हुई बैठक। पीएम मोदी की अध्यक्षता में हुई सीसीएस की बैठक। घायल ईरान का पलटवार। पश्चिमी एशिया में जारी संकट के बीच हुई बैठक। पीएम मोदी की यूएई के राष्ट्रपति से फोन पर बातचीत। अरब देशों ने की ईरानी हमलों की निंदा। यूएई पर हुए हमलों की कड़ी निंदा की पीएम मोदी से। भारत इस मुश्किल समय में यूएई के साथ खड़ा है, पीएम से ईरान पर हमलों की बौछार। यूएई में रह रहे भारतीय समुदाय का ध्यान रखने के लिए जताया आभार। तनाव कम कर क्षेत्र में शांति, सुरक्षा और स्थिरता का करते हैं समर्थन। मिडिल ईस्ट में तबाही। ईरानी सैन्य ठिकानों पर अटैक। ईरान में गर्ल्स स्कूल पर हमला। ईरान में रात भर बमबारी। मौजूदा क्षेत्रीय स्थिति को लेकर हुई बातचीत। पीएम मोदी से हाल के घटनाक्रम पर भारत की चिंताएं साझा की। संघर्ष जल्द खत्म करने पर भारत का जोर। नागरिकों की सुरक्षा को प्राथमिकता। दुबई और अबू धाबी के शेयर के लिए बंद। रुकने को तैयार नहीं ईरान, यरूशलेम पर छोड़ी मिसाइलें। दोहा में स्ट्राइक, दुबई में बमबारी, यूएई में धुएं का गुबार। डोनाल्ड ट्रंप, भारत बातचीत करना चाहता है ईरान। डोनाल्ड ट्रंप से बातचीत करना चाहता है ईरान। ईरान की ज्यादातर लीडरशिप खत्म हो चुकी है। ईरान को पहले ही बातचीत कर लेनी चाहिए थी। The basis of responsibility has been said to be essentially delictual and based on faults requiring either international or negligent conduct on the part of the state before a breach of it or an international obligation can be established, or to be strict or objective conduct and result alone establishing the breach of an obligation. There is no single basis of international responsibility which may be applicable in all circumstances. In fact, the basis of responsibility depends on the particular obligation in question. For example, the responsibility of state for acts of right of private individuals is based on fault for normally it is required to be shown that the state failed to show diligence in preventing either the injury or punishing the offender. But in certain areas, dangerous activities responsibility may arise without fault. In certain dangerous activities, absolute or strict responsibility has been fixed in it is such as Vienna Convention on Civil Liability of Nuclear Damage, 1963. Convention on International Liability for Damage Caused by Space Objects, 1971, and the International Convention on Civil Liability for Oil Pollution Damage, 1969. So far, 40 countries have ratified Vienna Convention on Civil Liability for Nuclear Damage, 1963. The Convention on International Liability for Damage Caused by Space Objects, 1971, has 89 parties as of January 2013. International Convention on Civil Liability for Oil Pollution Damage 1969 has been ratified by 133 countries as of 2013. State responsibility for injury to aliens. Under international law, it is generally agreed that aliens living in a state should also be conferred upon the same rights which are given to the citizens. It is the responsibility of the state to protect the rights of the aliens in the same way as they protect the rights of their citizens. State responsibilities towards aliens may be of the following types. State responsibility for acts of private individuals. Under international law, each state is under a duty to exercise due diligence to prevent its own subjects as well as foreign subjects who live within its territory from committing injurious acts against other states. While the state responsibility for official acts of administrative officials and members of armed forces is extensive, the responsibility for private persons is limited because in practice it is impossible for a state to prevent a private person from committing injurious act against the foreign state. The duty of the state is simply to exercise due diligence and where injurious acts have nevertheless been committed, to procure satisfaction and reparation for the wronged act as far as is possible, by punishing the offenders and compelling them to pay compensation if necessary. If the citizens of a state cause some damage or harm to an alien in that state, that alien gets the rights to file the suit for compensation according to law of that state. Thus, in such a situation, the state tribunals protect the rights of aliens. It may be noted here that the decisions of the state courts are binding upon the aliens in the same way as they are binding upon the citizens of the state. But if the citizens of the state tribunal is arbitrary and against justice, the alien person has the remedy to approach his home state to settle the matter through political means and ensure that the matter is decided in accordance with the principles of international law. Since in such matters the political matters are involved, it would not be correct to say that there is any state responsibility in the connection. State responsibility for acts of mob violence. State responsibility for acts of mob violence is same as for acts of private individuals. Generally, state may be held responsible for mob violence only when it has not made due diligence to prevent it. Outbreaks of mob violence resulting in injury to the aliens raise regularly the question of prevention as well as of redress. While occasional outbreaks of mob violence may be accepted in any state and their mere occurrence is not of itself a ground of responsibility. The state is expected to use due diligence to prevent them. This test is very uncertain and ambiguous. Due diligence to prevent mob violence depends on the time, facts, and circumstances. This test is so ambiguous that often jurists express the view that there is no state responsibility in respect of mob violence, but this view is not correct. Some countries such as England and America do not support this view. If the alien person is some officer of foreign country, then the state responsibility is further increased. As regards the vagueness of the test and definition of the term due diligence, obviously no very dogmatic definition would be appropriate since what is involved is a standard which will vary according to the circumstances. And yet, if due diligence be taken to denote a fairly high standard of conduct, the exception would overwhelm the rule. The report here for the International Law Commission on State Responsibility, Gracia Amador, concludes that the basic principle is that there is a presumption against responsibility and proposes the following provisions. The state is responsible for injuries caused to an alien in consequence of riots, civil strife, or other international disturbances if the constituted authority was manifestly negligent in taking the measures which in such circumstances are normally taken to prevent or punish the acts in question. There is some authority for the view that the granting of an amnesty to rebels constitutes a failure of duty and an acceptance of responsibility for their acts on the basis of a form of estoppel. But in many cases, the interference will be unjustified. Reference may also be made here to the case concerning United States diplomatic and consular staff in Tehran, which involved the acts of rioters and other militants who attacked and occupied US diplomatic and consular premises in Iran. The rioters and militants also seized the occupants and held them as hostage. Since the rioters and militants were persons without official status in the initial stages, their acts could not be imputed to the state. The International Court of Justice held Iran not responsible for the initial stages of their acts, but subsequently the situation changed. When the militants became agents of the state and hence Iran was held responsible for their acts, the world courts also held Iran responsible for breach of its international responsibility to take steps to protect American diplomatic premises and to restore status quo. What are its illustrations? A Portuguese subject residing in India is mobbed and is properly plundered by the mob on India, refusing to pay damages to Portugal. Portugal blockades the Indian coast and orders the capture of Indian vessels. In this case, India would be responsible for injury to the person and property of the Portuguese subject if she did not take due diligence to prevent the mob violence or if she was manifestly negligent in taking the measures which in such circumstances are normally taken to prevent or punish the acts in question. But the Portuguese action amounts to reprisal, and one of the conditions for a valid reprisal is that there must be a certain proportion between the offense and the action taken in reprisal. Obviously, in the present case, there is no proportion between the injury caused to Portuguese subject and the reprisal resorted to by Portugal. Moreover, no state is entitled to resort to reprisal which may endanger international peace and security. State responsibility in respect of injuries suffered by person serving the UN. There is also state responsibility in respect of the person serving under the auspices of the international organizations. This conclusion can be validity. This conclusion can be validly drawn on the basis of the decision of the International Court of Justice in the case of Count Bernadotte or the case of reparation for injuries suffered in the service of the UN. The facts of this case were as follows. Count Bernadotte, along with a French observer, was appointed by the United Nations Security Council to mediate in the conflict between Arabs and Jews in Palestine on September 17, 1948, when he was in that area of Jerusalem, which was under the occupation of Israel. He, along with a French observer, was murdered. In this connection, the General Assembly of the United Nations requested in 1948 the International Court of Justice to give an advisory advisory opinion as to whether in such matters the United Nations can claim compensation and damages for organization and the person appointed under its service. If questions were answered in the affirmative, it was further asked in what manner the action taken by the United Nations could be reconciled with such rights as might be possessed by the state of which the victim was a national. In its advisory opinion of 11th April 1949, the court held that the organization was intended to exercise functions and rights which could only be claimed on the basis of the possession of a large measure of international personality and the capacity to operate upon the international plan. It followed that the organization, in this case the UN, had the capacity to bring a claim and to give it the character of an international action for reparation for the damage that had been caused to it. The word court further declared that the organizations can claim reparation not only in respect of damage caused to itself, but also in respect of damage suffered by the victim person and titled to him. Although, according to the traditional rule, diplomatic protection had to be exercised by the national state, the organization should be regarded in international law as possessing the powers which, even if they are not expressly stated in the charter, are conferred upon the organization as being essential to the discharge of its function. The court held that the organization has the capacity to claim appropriate reparation, including also reparation for damage suffered by the victim or by persons entitled to him. the risk of possible competition between the organization and the victim's national state would be eliminated either by means of a general convention or by a particular agreement in any individual case in pursuance of the above decision. The Secretary General of the UN claimed compensation from government of Israel for the death of Count Bernadotte and a French observer. The government of Israel paid the money in the form of compensation, but refused to accept any obligation under law in this connection. In other words, we may say that although Israel paid the compensation, but it did not accept that it was its legal responsibility to pay compensation arising out of mob violence. Thus, the legal position is that a state is responsible for injuries caused in its territory to person serving the UN or any other international obligation. I thank all the listeners, learners. I thank all brothers, sisters, ladies, gentlemen, students, scholars, teachers, trainers, professors, professionals, officer, official, distant learners. I thank all honorable advocates, supervisor, administrative advisors. I thank all honorable advocates, supervisor, administrative advisors. I thank all honorable ministers and managers. I thank most honorable President Modi ji, Madam Pragesh USA from heartily, cordially thank all of you. Thank you.